This podcast is a Sepulveda Sanchez Law production.
John Stenson is a litigation attorney with over 16 years
Of litigation experience.
He was previously a partner at a national litigation firm where he headed the securities litigation division and has also served as corporate counsel for one of the largest privately held investment banking firms on the West Coast. He began his career as a district attorney prosecuting felonies and misdemeanors in Illinois State. He's now focused his practice full-time on trials and catastrophic injury cases. I'm Gabriel Sepulveda Sanchez, CEO and founder of Sepulveda Sanchez Law,
An award-winning catastrophic injury plaintiff's law firm.
Sepulveda Sanchez Law has earned a spot on the Inc. 5000 list as one of the fastest growing law firms in the nation.
In each episode of the podcast,
I selectively choose market leaders, entrepreneurs, and self-development experts to share their insights on how to become a better lawyer, business owner, and person. This is Beyond the Bar. Enjoy the show. All right, John, thanks for coming on, bro.
Yeah, absolutely,
Good to see you
man.
again,
Thanks for having me.
Appreciate that, bro. Thank you.
Oh, it's a pleasure.
So, one of the things we had a big trial coming up, and we have a dog bite case coming up in October in San Bernardino. It's not your typical dog bite case. It's not a strict liability case. It's a premises liability. We're suing the owners of the hotel.
Yep.
But we did have our experience last year together trying that minor impact soft tissue case. So what I wanted to do today is, since we had the trial coming up, kind of rehash some of the learning lessons we had from that trial and kind of just talk about our experiences together on that.
Yeah.
So that was a good experience, man. I think
absolutely.
Trying that case did a lot for me. We talked about this, like, hey, you know what? You always hear these guys getting big verdicts on catastrophic injury commercial policy cases, but when you can try a case that you're got a high chance of losing, not any property damage whatsoever, a little dent or bump, and someone's claiming injuries. That's, for me, when you can make that happen and get a decent verdict or just get a verdict, that's what makes you a good lawyer, in my opinion. And that case was no easy ride, man. Yeah.
It's funny when I think about that case, because like the expression "ignorance is bliss." If we would have known how bad that case was,
yeah.
We honestly were like, oh man, this is a great case. We know we got our problems, but I think had such a level of confidence going into it, and we wanted to put it all on the line.
Yep.
But we had no clue. Yeah. How bad the case was until we started talking to other people about it. But a huge learning experience. Yeah. And just the bonding, the brotherhood, learning about the science and the mechanics. It's a great experience.
Yeah, it's something that we always we were talking about it for a lot afterwards, but then it died down. But it's always something you have in common with someone.
Oh,
right?
Yeah.
Yeah, I think, like you said, we see things biasly, with a bias. And I think the one thing I regret not doing was the focus group on that case. Yeah. Because that would have managed my expectations. I would have saw things I needed to address. So what I want to ask you is, we did a focus group on this dog bite case, and it was eye-opening for me because I had some issues with witnesses. I perceived the case a certain way. Thought it was worth a certain amount, maybe a lot less than what the focus group people did for us. But what's your biggest takeaway with, doing the focus group, man? Why was it so important?
Well, two things. Two things. One before that. I think if we would have did the focus group on that, we never would have tried it.
No.
Because they would have said, you nuts. I think my biggest takeaway from the focus group was some of the things that attorneys that we key on and that we obsess about, like, oh, this is going to be terrible. Our kind of our star witness, so to speak, has a checkered past, and they're not going to think she's credible. Yeah. But when we spoke to the focus group about that, and we gave them that fact and kind of gave the background about what happened 20 years ago with her. It would definitely, I was comforted that, it's not a huge issue. A lot of the things that, you often focus on aren't that important to jurors. We think it comes down to this one little factor, but they look at the case, they really had a perspective on the case, and they looked at more than just, this lady made a mistake. They said, well, look, single mom, she, 20 years ago, people make mistakes.
Yep.
And, sometimes we don't give laypersons enough credit.
Yeah.
Because quite frankly, I mean, the fact that, she had this issue 20 years ago really has no relevance to, what happened with our client.
Oh yeah. Yeah.
So that was probably the main takeaway I got. Some of the things that you obsess over as an attorney aren't necessarily that important.
Overanalyze and stuff. It's so true, because with that focus group, like you said, there's some things with the witness that I was concerned about, and what I learned, the biggest takeaway in the focus group was that what you're worried about, they're not thinking about.
Yeah.
It's the stuff you're not thinking about that they're thinking about.
Yes.
So like you said, we kind of, and I think we're going back to that miss case we tried last year in Long Beach. I think that we definitely should have done a focus group. We probably wouldn't have tried that case, but
right.
it is what it is. We learned a lot. We're good guys. So we liked the client. We spent a lot of time with her. Mm-hmm. She was a good person, and we wanted to go to fight for her. They weren't giving her a good offer. I think they offered 10 and, weren't giving us any more money. But the jury is only going to get their personality for like 2 hours.
Yeah.
We spent hours with her. We know her history, church going lady, all that good stuff. But they don't know that. Yeah. And then also the way they present themselves to you is different from how they present themselves as they testify. You get different, man. Your nerves get up there. You're kind of clammy. You're choked up. So yeah, man, it's a big thing. Focus groups, I really believe that saying that it's almost malpractice not to do focus groups. Yeah. Like you got to do them. Like do yourself a favor, more importantly, do your client the favor and and we, with the dog bite case we had, we brought the main witnesses to that. And so they can hear, so the focus group can actually see them and make a good evaluation. And, it manages everyone's expectations.
Oh, absolutely. Absolutely. And it's also kind of like even a test run, right? How will this witness, how will she present in front of, 8 to 12 people that she doesn't know? Yeah. And it really made me much more. I mean, I'd always been confident in her because she's, very engaging. She's, high on the kind of likability quotient. But, we were able to see like, hey, she'll present well in front of, in front of a jury. Yeah. And she brought it home. Oh, yeah. I mean, that focus group, it's definitely
got to do it, man.
You got to do it. You got to do it. Yeah.
I remember you were like, hey, Gabe, you got focus group. I'm like, man, I don't want to know. I got so much. I am like the biggest focus group fan right now. Yeah. Oh, I'm like, after I did a legitimate one, like I am all about that. Yeah. But you were like, hey, Gabe, we got focus group. We got 2 months. We got a few months for this trial. Like, why are we doing this, man? I got so much, man. I was like, my case though, man, you ain't got enough cases, man. I'm too busy. No, I can't do it. You talking about, hey, you got to get that opening. Oh, man. So that's, and like you said, the best thing for me too, is like, it forces you to prepare. We had an opening statement already done. Like we had our direct, we had we showed some evidence to them. And then the cool part that I always crack up on, man, because I didn't see this coming at all. So I had my opening, and I thought I had no idea you had planned this. You had a defense opening, and it was, dude. Oh my gosh, man! Like that was funny. I was listening to you, and I'm like, dude, this guy, man. Like you talked about all this. I've come away. I'm an immigrant in the United States, and I was looking for the American dream, and I found it in my hotel. All this stuff, like. We won't get into the specifics yet because, opposing counsel might be listening.
Right. Like, subscribing to your channel.
Yeah, man. Yeah. So anyways, in any case, I remember listening to your focus group, and I mean, your opening in the focus group, and I was like, damn, dude, that was pretty good. Like, you made this place look like Disneyland over there. And then it's funny because one of the witnesses, they were even like confused, like, did this guy bring a defense attorney or something like that? So
that's hilarious.
It was funny, man. Like that was good. And like you said, the real powerful part is you almost have a mini trial, and it forces you to prepare.
Oh yeah.
So I always tell people, after we get that verdict, and here's the thing, man. Was it a big verdict? No, but I'm like really proud of it still, because that's a case I really think we probably should have lost.
Absolutely.
Not to discredit the client. It was just there was no property damage. It's like the bump. And,
Yeah.
And we had it was a tough case, but I always tell people, like, listen, if there's any advice I can tell you on missed cases, like, first of all, think twice of whether you really want to try those cases, because everyone likes to talk about their wins, but no one's really talking about their losses.
Yeah.
And there's a lot of lawyers that have lost those cases, and we could have lost, because
Oh
we could
yeah,
have lost
definitely.
big on that.
Yeah.
But I always tell people, like, you need to really think about whether you want to try those cases. First things first. Now, if you decide you do want to try it and take that risk, this is another thing I learned about this, like, trials, especially if you're the owner of the firm and it's your capital you're investing. Like, make sure you're comfortable with losing whatever it is you're investing. Like, I knew in that case, like, there was a good chance. I knew I'm confident in our ability, and I'm confident in our skills, but I accepted, like, okay, whatever this, I think was it 60 grand. I don't know how much it cost in that. Like, I was like, hey, I gotta be cool with losing this money.
Yeah.
Like, you shouldn't be trying cases and investing in cases that, you need to know, like, if I'm betting this money, like, I'm okay with losing it. I'm not going to go down. I'll never try a case where I'm like, hey, this is all on the line, man. If I lose this, I'm going out.
Mm-hmm.
Like, I'm a risk taker, but I'm just a smart risk taker. So with missed cases, I would say the thing I've learned was that, first of all, really question whether you want this case to try. Like, your witness she better be good. There should be some upside to that too. Second is really think if you can afford to lose. Don't go overboard and hire experts, or you don't get underwater on a case like that. And third, man, just go in there and do your best. I think one of the things you taught me was in Keith Mitnick's book. I think where we really did a good job was that jury selection thing.
Yes.
Because we really, like, with you taught me about Keith Mitnick's book, Don't Eat the Bruises, and we really hammered home in voir dire, like, listen, everyone, there's not a lot of property damage here. Like, I'm not trying to sell you something that isn't there. Like, this is how the property damage could be described. Does anyone have any problem with someone claiming injury when there's barely any damage? And that voir dire was solid. We even got props from the defense attorney on that. Everyone they wanted in, we got rid of them. I think with missed cases, you gotta tell them, like, not how bad your case is, but how minimal the damage is. Mm-hmm. And you really got to root that out. So when they see the picture, they're not like, what the hell? Like, you need to hammer home. But what are your thoughts on that part?
I definitely thought the voir dire, that, there was a moment there where, I think you really found your voice and you got into your stride.
Yeah.
And I mean, I'll never forget that moment.
That was funny, man.
Hey, listen,
that was funny.
It's like Mike Tyson says, right? Yeah. Everybody's got a plan till they get hit in the mouth.
Yeah, I remember that part.
And so, you got all your little questions written out and everything. And, you're asking your questions, you're going down your list. And you get to, let's say, the fifth or sixth question, and no one's responding to any of them. And I just, as I'm sitting there, I'm like, I know he's going to look over here at me. So I commenced to put my head down. I'm like, no eye contact. And so I put my head down, and I'm thinking in my head, it's like, what is he going to do? And just in your Gabriel way, you went and asked the same question like you always do with me. Like, I'm like, gee, you asked me that question.
That's the OCD kick.
Yeah, right. 5 times in a row. And you went in and you went back down your list, but you asked individual jury members, hey, how do you feel about this?
Yeah.
And that elicited a response. And then you were like, you figured, you're a smart guy. Oh, I'm onto something. And you may have asked that person a couple questions, and then you went to someone else and you went right back down your list. You didn't, you could have easily just came, grabbed your papers, and sat back down.
Yeah, it felt like doing that.
Yeah, I know you did. I know. I felt it. But you stood in there.
Yeah.
And that was like, there was that moment where, you could have just kind of, been a shrinking violet and sat back down.
Yeah.
I mean, I would have given you a hard time later on, but but they wouldn't have known anything. They wouldn't, they would have thought that was normal. And instead, the voir dire, how long did you?
I think I was on my feet for at least 2 hours, maybe.
And that
longer.
was just one. I mean, there was just a straight session.
Dude, it felt quick, and then all of a sudden the judge is like, "Okay, tomorrow, second session." I'm like, "What?"
Yeah.
I was like, "It's 3 hours." I was out. Was I on my feet for like 2.5, 3 hours?
Yeah.
It went by so quick, bro.
Yeah.
Dude, it was like felt like I was in a dream.
But that was powerful. I think once you did that and you overcame that, that obstacle.
Yeah.
And you overcame just fear because, it's like, you're stuck. They're not responding like they're supposed to. This isn't supposed to happen this way.
It don't happen in the mock bodies.
It didn't happen when we were practicing it. And that gave you more confidence, and you went a little bit further and you got more out of it. And I think because you confronted that you were able to, like that one lady who, we were going back and forth about, and then once you were able to ask a few more questions, you were able to find out, you're an adjuster for an insurance company, or the other woman also that we used the peremptory against. But that was a very memorable moment.
I remember that. I remember how I felt, man. I remember I went out, I felt the best way I can describe that was like a bad comedian. Like, I wasn't trying to make anyone laugh, but like when you ask, like, hey, anyone here have any problems with lawsuits in America?
Crickets.
Woo,
Crickets.
Like, number 2.
Crickets.
What does everyone think about, awarding money damages for pain and suffering?
Crickets, man.
Like, I was like that. And I remember I was like this. I was like talking to jury, and I look at you, and you're like, "Don't look at me, man." Dude, I swear everything in my body was telling me like, "Yo, just sit down, dude, just go." And then I was like, you know what, dude? I was at that point where I'm like, I ain't got, you know what? Fuck it.
Yeah, I'm just gonna ask.
I'm just gonna start, dude. I was like, you.
Yeah.
And then people start opening up, man.
Yeah,
and then you have to go person by person, man. And you got to get them to talk. And then that one, we had this one lady we thought was going to be a good juror, and she was injured in a motorcycle accident. She had a lawyer against filing lawsuits. So, I was like, all right, cool. She's like, yeah, I can hear the evidence to be fair. I'm all right, cool. And then I don't know what told me to just like, I don't know, man, something just didn't seem right.
Yeah.
So, man, what do you do for a living? Oh, I should have told you this. I'm a safety inspector for, Nissan.
Yeah, yes.
Okay, I was like, okay, like,
that's right.
What do you do? Oh, yeah,
adjuster.
we do it like the crash dummies, and we look at safety, make sure the cars are up. Okay, like, well, like I said, this case, there's not a lot of property damage. Airbags didn't deploy. Would you, tend to believe that our client might not be hurt if there's no airbags deployed and barely any property damage? Yeah, I don't know. I would probably think otherwise, I was like, dude, like, but that was someone we were gonna keep on.
Oh yeah,
you know,
yeah.
And so it's just like, just because on the surface they look like they're for you, and you gotta dig. Sometimes you gotta double check those people, man.
Yeah.
And but what I loved about my memory with you on Vaudier, and I remember this, we were making fun of you, man. We were prepping for the trial a couple, the weeks before, and I remember you had this big old cardboard, and you had like the science fair project. And I'm like, John, what are you doing, bro? Like, we got laptops.
Oh, you're clowning me
like this, dude. And I'm like, man, I came in there. I'm like, bro, you got this big old board, man. And then with Vaudier, though, when we were picking juries and getting rid of people, man, you had it all lined up. You had the tags, and it was like musical chairs. This one's gone. This one's coming in. And the best part, man, is even defense counsel, man, they're like, hey, man, they were using that as a reference and shit. Like, oh, shit, like, and even told us after the trial, I was like, man, that's a good idea, like having that thing, because you can visualize it better. Dude, so I was like, John, good job on that board, bro. Like, that's good, man. Hey. And then when you had that medical thing you had to go do, but I had that board. And I'm like, all right, cool. Like, you're something. I was like, man, that was good, man.
Yeah.
That was good.
It was, just having that kind of like that whole collaborative effort and everybody working together and that voir dire, because I mean, it is probably, the most important part of the trial, making sure you get the bad jurors off. But yeah, I mean, we were extremely organized, and it just flowed. And I think having that level of preparation and organization, for us picking our first jury in California, it made it go much smoother.
Yeah, man. The trials, you gotta have some fortitude and courage to do those things, man, because like, it's no joke, man. Like, this is, your client can lose some money, like, you can lose some money, like, and I think what I was telling my friends, like, trying cases like that, especially someone like that, a tough case, man, it's a game changer. It changes the way you see everything. Like, I look at discovery differently. I take depositions differently. If I think this client is not likable, I'm very careful about, hey, you know what? Like, maybe this relationship isn't going to work out. Yeah. And maybe you should be with another lawyer. Because when you go to trial with someone, you better like them, man. Because if you don't like them, the jury ain't going to like them.
Yeah.
And I mean, if you don't like them, like, and I'm a pretty chill guy, and I'm cool, man. I like people. But if I have a problem with you, I'm pretty sure a lot of people aren't going to like you either, Yeah. So, man, it's something that those things, even if you don't want to do trials all the time, like, you should do one once in a while, just because it's going to change your practice.
Oh, absolutely. Yeah. So. No, like you said, I mean, when you decide to bring these cases in, you have to look at them and say, hey, I may have to file this thing, and I may have to sit with this person for, 5, 7, 10 days. Yeah. And there has to be some level of connection. And if you don't have that can, even, even if it's not a person that you would necessarily, go have a beer with, you got to be able to connect with them on some level. Definitely.
I told someone today, like, you know what? You have to be honest with them. Like, you have to. I told someone, hey, listen, man. Like, this is liability is good in your case. The only thing's gonna hurt your case is you. Yeah. You got a temper. You complain a lot, and like, you got to be likable. Like, if I have issues to do, jury's gonna. They're not here to. They don't want to sit in court and listen to your complaint all day. So yeah, it's important, man. You got to be likable. You gotta have a good client. Yeah. And sometimes you guys got to put it and tell them how it is. Like, listen, man, like, you gotta be cool. You gotta have a better attitude about this. You're complaining. The insurance companies, I always tell people, they don't feel sorry for you. Mm-hmm. Like, it's a slip and fall. You got your back hurts a little bit. You got a few pain management injections, epidurals, whatever. Like, these guys just handled a case where, like, some family members got killed in an accident. So when you're over here crying and complaining about, the store manager didn't come in and get your witness statement in time, like, dude, you better, these guys are not going to feel sorry for you. So in your deposition, answer the question, don't talk too much, and don't complain. Mm-hmm. That's what I tell people. And yeah, you hate to be like that, but I think I learned, man, that if you know trials, like, listen, man, you gotta. This isn't a game. Like,
Oh, no.
you better just, don't be acting all stupid.
Yeah.
Pretty much. Like,
Well,
Yeah.
even with our trial, I mean, we had our witnesses that, the people that talk about all the things that our client couldn't do and all the sad stories.
Yeah.
They're the ones that have to kind of give that story.
Exactly.
And, I guess one of the other things, one of the other major takeaways that I had from that experience is how important those, your kind of your, I guess, occurrence witnesses or whatever. I forget the name.
Lay witnesses.
Your lay witnesses are for, your case, and how they're the ones that help set up your general damages. They're the ones that help set up the whole pain and suffering and tell that side of the story. Because, again, you don't want your client to, hey, feel sorry for me. I can't do this. I can't do that. You want them to kind of present it. They're the ones that are your client's voice as far as the general damages are concerned. Yeah. So learning also just how important those lay witnesses are.
Yeah. That David Ball in that book, Damages, talks about that. It's so true. It's like, you want to have your damages, you want people to testify about your damages because you can come off as a complainer, So
right. Yeah.
And I think that's what helped us out too, was stacking up those lay witnesses about, hey, you know what, now after the accident, my shoulder, I'm having, she doesn't garden anymore. She's been tossing and turning at night. I had trouble showering. You want to hear that from other people, So let me ask you this, man. So what have you learned about me, like working with me in a trial, what to expect, like things that I did good, things that he's like, man, I think it was good. Because I'll tell you what I learned,
Yeah.
So.
You're a hard worker. You're passionate about being a good attorney and representing your client to the fullest. The one thing that, I think, and, we both talked about it. I mean, there are things that we both can improve on. And we both, we didn't know the science as much as good as we should have known it.
Yeah.
Right. And we didn't know the medicine as much as we should have known it. But sometimes, you have to have that experience to know, okay, this is where I really need to kind of brush up. Yeah. Right. And fortunately, we were successful and, we got a decent result, all things considered. But just, seeing that, okay, there has to be a little bit more preparation on the front end. Yeah. And I think we both learned that, because I think sometimes you get so many of these cases and you do so many depositions that you don't realize that, hey, this is the point where I really need to learn something about their theory. Yeah. And so I think, that's something that you and I both could have improved on. Yeah. But overall, the way that you handled the voir dire, I thought was awesome. I thought you did well with their medical expert, Dr. Kavitny. And I thought even in those moments, those unexpected moments where you could have basically sat down and just, and you still stood in there, right? Yeah. Whether it was during the voir dire or even during the rebuttal, right? And it's like at that point, you'd put so much energy into this, and we're at the final day, and you're the night before, you're up probably, it's like we were in law school again, right? You were sleeping on my couch. And I told you, at 2, I was like, hey man, look, I'm going to bed. And I imagine you probably stayed up till 4 or 5, and we had to be up at 7 and get over to Long Beach. But you still, you ain't no punk.
Yeah.
You still like, it's like, hey, look, now I got to go do the illicit rebuttal. And, kudos, hats off to defense counsel. I mean, I thought, they had a really good closing. And we both felt it, and it's like, man, we killed everything else. You killed the opening, Void Deer was awesome. I thought the evidence, the way that the evidence came out, I guess we're biased, but I thought it really came out better for us. But I thought he had a great closing. Yeah. He pulled it all together. Yeah. And then you having to go back up on stage after he just like blew it up.
Yeah, he had a good closing
and killed it.
You thought
and deal with that.
Yeah. He had and you talking about baseball and
he pulled it together.
Mike Piazza and she, about her playing, that's Dodgers shortstop money. And I'm like, man, this guy, I don't know what he's, but that was
he was an OG.
He was an OG, man.
Yeah.
And you know what the crazy? I always tell people, like, listen, like we all tried that case. Like this is a multi-million-dollar case. So we went out there, like, we're going in, like, we're gonna try, like, it's a multi-million-dollar case, and even on a small one like that. And he brought it too. He brought it, man. He wasn't backing down, like, but we all got respect from each other. He's cool with us to this day. Yeah. It's something, trying cases with someone, it's a bond.
It completely is from both, and maybe we were fortunate. I really think we were blessed. We had a great judge, and opposing counsel was a good guy.
It was a good overall experience.
Yeah,
like,
absolutely.
We could have been, not like the next case.
Yeah, right. But having that experience is like all the other stuff is not it won't surprise us. Like, you already know how to do void deer. Yeah. We prepared it on the front end.
The trial binders done.
The trial binders, yeah. Like a lot of stuff, man. We were like, kind of making it up as we went, right? So it's. Because a person can, they can give you a hard time, just like some of the evidence, right? Some of the evidence we didn't move in. Yeah. And he was like, he didn't give us a hassle about it. But now we're going to be on point with it.
Yeah. Yeah. So, man. Yeah. He was a little forgiving of some stuff, man.
Yeah. Absolutely.
Yeah, man. So one of the things I learned from you, and I was like, man, you did a good job of cross-examination. Was it their biomechanics expert?
Thank you.
And you blew him up. And then I was like, man, this is good, dude. And then I started talking. One of my criminal defense lawyer friends, he was a public defender for a while. He's like, hey, you got to read this book. It's Posner's cross-examination techniques.
Yeah.
So I got that thing. It cost like $300. We go thing. I was reading through it. And I'm like, hey, John, hey, man, I know where you got that shit from, bro. Like, hey, I said, you know about Posner? You're like, hey, man, I know about Posner. I'm like, hey, bro, that book,
amazing.
That shit just opened up, even like discovery, reviewing documents, man. I'm structured, I'm organizing. It's like a fine tooth comb, man. And I think that I'm not finished the book, but I think the takeaway is like, man, you got to get those concessions from them. Yeah. And you cross-examination is like death by 1,000 cuts. And that's what you're so good at. Cause John is very thorough. Like you're a thorough, man. You're like too thorough.
Hey, thank you.
I'm like, man, John, like, fuck, dude. Like, I'm like, man, you gonna bore you, you're gonna kill me, man. I'm gonna cut my own wrist, man. Like, but that's what cross-examination and depositions, you need to be super thorough. I'm a very, like, I get excited every time. Let's get this done. Let's go. Like, no, man, hey, hold on. Let's go through everything. Yeah. So, tell me, like, with cross-examination, because you did a great job on that. Even at our focus group, the people are like, hey, you know what? Because we both did a direct and cross on that, and they're like, hey, John's, got the skills on that. Let him flow with it. What is it with cross, man? What do you like? What's your secret, or what's your tip for other lawyers out there on that?
Well, I mean, initially I was a prosecutor, right? DA. So I did that for a couple years. And then when I had a practice in Illinois, I also had a contract doing public defender work. So I've had an opportunity to do this a lot, right? So, I've done a lot of criminal jury trials and bench trials and things like that. But I think that the main thing that and it doesn't matter, right? You can, there are at least 4 or 5 things you can cross anyone on. Yeah. bias or just, some factual things that may be incorrect. But I think, and I took it basically out of that book. Like you have your chapters, like that one issue that you want to discuss, right? So, like with their biomechanics guy, we knew that he didn't go to the location and, he didn't really go do like the physical analysis of the hill or the street, right? Which was on an incline. And so, that was one of the things like, hey, isn't it important, if you're giving a scientific like analysis or opinion about something to go see the actual location. And, I would probably like chapter that, physical analysis or something and ask 7 questions kind of dealing with, isn't it important to go look and go see and all those things. And so that's what I do. I, create these chapters that are like, like a little outline and ask those 4 or 5 questions, but never ask that last ultimate question, right? Because that's closing. You want to close on that, and that's always been my approach to it. You're always going to get a little bit out of the client. You're never going to have that got you moment. And I think oftentimes people will ask that last question and it goes left, or they're hoping to get that got you moment. But if you just, you have your theory of the case and you have, your theory of how you want to examine that witness. And, I read all of his, the reports he was relying on. I read other depositions that he, that were conducted, where he was a deponent. And so I did my homework. I did a lot of preparation. You handled
that guy really good.
Yeah. And that was preparation. It wasn't, I wasn't some fly by the seat of my pants thing. It went down that way because I put so much time into it.
Yeah.
And so that's the first thing. I mean, I think the first thing is, you got to do the work. You got to, read what they have out there. You got to look at other people that have deposed that person. You got to do the work. And then, you have to create your outline, have your chapters and your little theories, and where you want to go, get your, 5-6 points out of it, and then sit down.
Chapter method. That's what Posner talks about.
Yeah.
And the cool thing too, I noticed you had good witness control, man. Like you asked that question, and even though he was trying to, I'm like, listen, this is a yes or no question.
Yeah, exactly.
And so like you had witness control over it, and that's what in the book what I'm learning about is like it's like you need to like have those specific questions, and you need to make them like, hey, this is a yes or no answer. Isn't it true this? Isn't it true that? Once you ask open-ended questions, you give them opportunity to start talking. You got to just get that specific question, and just really, like, man, you had witness control in that dude, bro.
Yeah, that's it's important because you do have those witnesses there that are, if you ask that open-ended question, they're gonna sit there and they're gonna just give, they're gonna give that kind of stock answer they have, and have another opportunity to kind of feed the jury their theory. And so that yes, no, the closed-ended questions, the whole yes, no, and pointing out to the jury, like, hey, you see this guy is taking, he's not playing by the rules.
Yeah.
He's doing, he's trying to basically give you his theory. Yeah. He's not answering the question correctly. I think that's important as well, like to try to demonstrate control over them. And then, at some point you also have to ask the judge, say, hey, listen, I'm asking yes, no questions. He's giving non-responsive answers. I'm going to ask you, could you please admonish the witness? But yeah, again, I think it's preparation, and that comes from experience.
Man, you handled it, honestly, man. You were on point with that shit. I was in there watching like, damn, dude, man, I didn't even know he was that good, man. He's over here, But yeah, that was that book. I read that on my answer. I'm like, I was like, oh, I know he learned this shit from here.
Oh, absolutely.
That's a good book.
Yeah. That's like,
dude, you have to
that's
read
a must
that.
have.
Cross-examination by Posner. So the lawyers listening out there, you gotta read that one.
That's a must have.
Yeah, I don't know if it's a criminal defense thing because my criminal defense lawyer referred it to me.
That's when I got it.
You told me,
yeah, I got it when I was a prosecutor, and it was just like research. I'm like, oh man, because I wanted to be good at cross-examination.
Yeah.
That book, and I think there's this different. I think the approach with deposing someone is different than how you cross-examine them at a trial. Like I almost think you kind of let them talk during a deposition. You don't try to have those gotcha moments. Like you let them explain everything so that you know what their theory of the case is. Because they came when they came into the trial, they had this theory that we didn't catch.
Yeah,
right.
That's another thing we.
But you got to let them talk and get as much out during the deposition, and then you hang them at trial. But that's a definite must-have book.
Yeah, I think one of the takeaways too was we always watch these movies. We got that aha moment. But you got to let the jury get all these concessions and let the jury make the inference. The jury make the inference. You don't have to get this aha moment. Like, isn't it true that, this was dark out this night? Isn't it true that the speed limit is 65 miles an hour? Yeah. Isn't it true that you were going 67, 8 miles an hour? You let the jury make these inferences instead of you going in there and trying to be all suave and everything. It is cross-examination. I think it is death by 1,000 cuts, man. That's how you're good at that stuff. Yeah. I'm like death by one machete.
Yeah.
It's good. You need that though.
Well, and the other thing is too, it's like, and that's why when you try these cases with you have a partner and you're trying these cases, which, who would do better and where, but also it's like, I have to be working in unison with you because there may be certain questions you need me to ask this witness so that it falls in when you're doing your closing, you can point that out. He didn't do this, he didn't do that, and so that's team. It's so much. Very much a team effort.
One thing I learned, man, in business and with trials, it's like you got to get rid of your ego. Like you got to understand like your role and what you're good at, and you got your strengths, you got your weaknesses. Like have that other guy. It's just like a baseball team. It's like, okay, like I can be a good first baseman. Do I want you being first baseman? John, do I play first base better? Yeah. John, is he a better outfielder? Is he a better center fielder? He's got the speed, whatever. Like, well, can I play outfield? Yeah, I can play outfield. But who's better to play outfield?
Exactly.
And you have to realize with trials, man, and it's like you got to get rid of the ego. And you have to like say, this is my strength, man. This is what I like. I like the people. I like the jury. I like the opening statement. I like the picking a jury. I like the risk. I like the rush of it. I want to get in there and just get it. Let's go get it. But you need that. You need the, hey, this guy's better at the witnesses. He's better across. He's better, more thorough. He's not going to rush everything. So like you have to understand like, this is my position. Like we're all in the same, we all need each other. Like, and understand that. So that was a big takeaway for me. Like, hey, it ain't about you. Like trials aren't about you. It's about the client. It's about getting that W, getting that verdict. Yeah. So do what you got to do to win. Hey,
Magic had a role. Kareem had a role. Yeah. Everybody has a role. And if everybody plays their role,
everyone has a role.
And it's funny, sometimes like how your virtues come out in trial, and sometimes the things that you don't do so well can come out in trial also. And I always tease you about you asking me the same question in 7 different ways over the course of 7 days. But that about you, that characteristic, your OCD. About asking those questions, it came out and it boded you well during voir dire, right? Because you're going to continue to ask the question. You may ask it in a different way, and you would always come back to someone like you'd ask someone else.
The sheriff's wife. Oh, right? I gotta get this lady off the jury, man. She's gonna kill us.
And the one thing, and this comes to mind. I think we both need to do better at the next trial. Is using our bats, objections, getting people off for cause.
Oh yeah, definitely.
Yeah, we gotta focus
Some
on
more
that.
research on that.
Yeah,
and
yeah,
stuff.
yeah.
Yeah, man.
We can do that better. We can do better on that.
Oh yeah. Oh yeah. So, we got another trial coming up in October, and this one I feel a lot more confident on, not because it's a better case, it's because we just got some more experience and we know how we operate with each other. So, it's a dog bite. When I talk about this case with other people, oh yeah, dog bite, that's simple, strict liability. Well, no, not on this one. Yeah. It's like, because we're suing a hotel owner for that one of their guests' dogs that was off on a leash on the property. So tell me, in our audience out there, like, what is this? How's this case different from other dog bites? And what do you think, how do you say it? Like, how is this case different from other dog bites out there?
Well, I mean, liability is at issue, right?
Yeah.
So basically, their version of the events is that this dog that was at the hotel, that they had no notice of it, right? So, it's a premises liability case, and you have to show that the person who owned the premises knew or should have known about the danger that existed, right? And so their liability is at issue.
Yeah.
And quite frankly, damages are at issue. So, I think that, it's a tough case. It's a tough case for us. I mean, our as we mentioned earlier in the, at the beginning of the podcast, we have a witness, our star witness, who has a checkered past.
Yeah.
And, that could haunt us.
Yeah.
I think we were, we became more confident, during the focus group that, maybe these people won't focus in on that. Right. But yeah, so we have to show, first of all, that they had notice of the dangerous condition, that the property owner knew that the dog was there.
Yeah.
And the other thing, they not only did they know that the dog was there, but they knew that the dog had a propensity for being a dangerous animal.
Yeah.
Right. So, this is a little bit different,
Now you're right. Some people, it's dog bite. Oh my dude, no, it's saying that.
Right. It's not that. I mean, it's not a strict liability. So, we have to know that not only did the owner know that the dog was there, but they knew that the dog had this dangerous propensity.
Yeah.
And, that's based on the dog killing other animal on the property.
Gotcha. Yeah.
Right.
Yeah,
and so those are the big issues. And then I think that the other issue that we'll have to deal with is the extent of the damage. So, I mean, we're hitting all the,
we're going in there like, hey, man, it's going to be, we're going, it's throwing down.
This one is going to be a fight.
Yeah.
This one's going to be a fight.
I love this stuff, though, man. But there's nothing like, it's nothing like the feeling of getting that verdict, dude.
Yeah.
Like, I'm win or lose, man. I thought I'm gonna feel good about whatever happens. I know I put it down. Like,
absolutely.
It's just we worked hard. We, when I know I did everything I could to get a win, like, I feel good. And it's when I don't fight. And man, I think my uncle and my dad taught me this, man. And he was like, listen, it's not about winning or losing. It's about just throwing down, man.
Yeah.
Like,
it is.
I know it's some hood shit to say, but it's so true. It's like, man, we just put so much work in, and yeah, the win's good, but it's really just about, hey, I did everything I could in my capabilities to get this guy a good result. And
And the thing, you're a very compassionate guy, and you really want to win this for the client. You really, this is a client that, grew up on the other side of the tracks, just had it, had a tough life. Yeah. And, hopefully, we're able to be blessed and get a verdict that's favorable for him. And, can compensate him for his injury and maybe help him go to school, go to college.
But this is the kind of stuff though that makes you feel good about your being a lawyer though. Like anyone that does personal injury law, unless you have a practice that's just full of big cases and big injuries and good clients, we all know that. And there's sometimes I have days where I'm like, you know what, like I've done everything I could for this client and he's not happy. He's not even that hurt that bad. But when I have cases like this where I'm like, man, they're not doing him justice.
Yes.
It's like this, honestly, like, yeah, of course we all want to make money in this case. But really it isn't about, for me, it's like, hey, I know what they're doing. It's not right. And I want to teach these insurance companies a lesson. Like,
absolutely.
Listen, man, like, let's put it in the jury's hands. Like, and it's so true. Like, they freaking tripled their offer already, and it's still not enough. We kind of talked about it in our focus group. Like, you know what? They need to put up more money.
Yeah. And
So-
you talk to the client.
Yeah.
You
And I
said,
put it
hey,
out there. Listen, this is the risk. I'm like, listen, this is your money.
Yeah.
Like, this is the risk we have. Like, this is what they're offering. This is what I think. It's your choice.
Yeah.
So, I mean, these are the cases this is why I went to law school. This is why I wanted to be a voice for the people that didn't have a voice. And this is the stuff I live for. Like, yeah, the settlements are good. You get big cases, big money. Yeah, it's great. But when you can say, hey, you know what? At the end of the day, I did this guy right.
Yeah.
And I did, I can answer one day when I'm long gone and I got to answer the Lord upstairs.
Yeah.
Hey, you know what? Like, how I am inside. Like, hey, this wasn't about the money. It really isn't.
No.
I'm just here like, listen, I'm here to do this kid right. Cause what's going on in our country with the money they're offering, it's not fair.
there's nothing glamorous about this case.
No.
It's like, you look at all the other cases, cases you have. This isn't, there's nothing glamorous about this. This is strictly like,
this is
this
all
is
American.
justice.
This is like, hey, this is jury.
Yeah.
This is justice right here in the jury system, man. So, yeah, it's awesome, man. But personally, how are you going to approach this case differently? Not like, I'm gonna say strategy wise, but what's your mindset going to be on this one as opposed to the last one we did?
I would say, in terms of, because there are no experts, because, these are all just, everyday people. And so, you have to kind of, the defendant is an elderly man.
Yeah.
And, you have to, there's a different type of approach that you have to have when, there still has to be some level of respect, but some level of like, I know you're bullshitting too.
Yeah.
I know you're lying.
Yeah.
And so it's just a more delicate, like when you're examining these people, it's a different approach. Yeah. It's a more delicate approach, but at the same time, you have to convey, you have to convey like, hey, look, guys, this guy, he's not being completely honest. He's trying to get over. I think it's a little bit easier because, the mother of our client, it's a little bit easier because she's a good witness. Yeah. So I'll have that, that'll be easy. But, I don't think that the approach is much different. Yeah. I think that, we're dealing with all, lay witnesses.
Yeah.
And so it's just really kind of getting the story, more preparation of them. I think we really have to, have,
definitely.
Making sure we're, everybody's prepared, and that's really it.
Yeah. I think when mindset wise with me, it's like, it's really just, I think a big thing is the storytelling and then also PowerPoints. Like, I think I was a little more experienced on that last trial, but like the PowerPoints in this one, and I learned this from Mark Lanier. If you look at his PowerPoints, when I saw his seminar, I'm like, this is some stupid ass clown shit. Yeah. I'm like, what is this? Looks
American flag,
Eagle. Thomas Jefferson. I'm like, this is stupid. How you getting? But when now I look back on it, it's like it's themes, man.
Yeah.
Themes are so big in jury trials.
Chapters,
like,
themes.
You got all this. If you have a bunch of writing on the PowerPoint, you're just like, it bores people. Like, what the hell? You have a picture, picture. This is how the client was before the dog attack. This is, this is how he is now. Dreams, like this is the dreams he had. He wanted to be a veterinarian before this happened. Now he can't. And then also just being silent. So to do my closing, I'm like, hey, you know what? Like, he had a dream.
I like that. Yeah. Well, but being comfortable in that
there's
silence.
Power in silence. Like,
you got to be comfortable in that silence.
Before this attack, my client loved dogs, loved them. He loved rescuing them.
Yeah.
Little things like that, man. Like I've been, silence is powerful.
Oh,
you gotta do that,
yeah.
man. Like you gotta think and let that sink in, man. And man, we're gonna win.
I think so.
I feel like we're gonna do a good job on this thing, man. And
we put a lot of time into it, man.
I want to, and I told you, I focus group this. Our defense counsel, I don't even, whatever, man. She needs to get a little more respect.
Yeah.
When you hear me listening, I'm coming. I'm coming for you.
You're gonna learn today.
I'm coming, man. You better call that adjuster up.
yeah, you better have on speed dial.
Yeah, but you know what, man? I focus group this. I focus group that we had our own neutral focus group that we put together. I talked about family with this stuff. Like, man, it's a good case.
I think so.
I think it's a good family and good people. So I
Yeah.
feel good about it. But why are I after trying more cases, I realized why jury trials are so important. But as a personal injury lawyer, why is it important to just try cases, man? Why do you got to do it?
So when I started, I got my first job as a district attorney, or back in Illinois, state's attorney.
Yeah.
So when I got that first job, I was talking to the head state's attorney. And so he was like, I told him, and I just had this very candid moment. I was like, look, I'm a little nervous about this because, I've never, I always thought myself as being, like a corporate attorney doing transactional work. And I was doing an internship at this place, or at the Federal Public Defenders, and saw this guy, and I'm like, oh, maybe this, this trial stuff is it's kind of cool. And he just had this swagger about him. And so I'm talking to the state's attorney back home, and he said, John, you know what the fear, the second biggest fear next to death is? And I was like, no. He's like, public speaking. And so he was telling me this story. He's like, what we do here is we are the ones that wear the white hats, and we are the voice for the voiceless. And, we try to protect people who have been harmed by other people. And so he said that, you see these people, you think, hey, this attorney, guy that lives next door, you see him getting his briefcase and walking to his little BMW and gets in and drives off and goes to work. And you're like thinking like, man, that guy's out there. He's out there killing it. He was like 90% of attorneys, they don't do this trial stuff.
No.
Right. He was like, but it's the 10%.
Yeah.
Those are the people that are getting in front of those juries, that are confronting those fears, that are, have that anxiety and have that stuff going on in their stomach when they're, doing that closing statement. But he was like, that's how you want to live. That's life. Like living on the edge, confronting that fear and getting out there and speaking for those people that don't have a voice. And so that, I'll never forget, that moment with sitting with him. He's now a judge. And I'm still, we were in communication, and just how much that meant. And yeah, I mean, I think in terms of litigating, that, I mean, we're the fighter pilots. We're the remember Top Gun, like we're those dudes. And I couldn't imagine having gone a different route. Like this is what it is.
I got into it for trials too, and sometimes we get off track. We got student loans, and we're trying to hustle, do what we got to do to pay loans, get different jobs. But and it's like when you're in front of that and when you're in that courtroom and you're talking to that jury, you're like, dude, this is what I signed up for.
Yeah.
Like, this is the epitome of what being a lawyer
This is it.
man.
Yeah.
You know, man, like this is it.
But yeah, when you looked at the lawyer shows, it wasn't the guy, making the best writing the best contract. It was the guy in there, in front of that jury.
Yeah. Awesome, man. Yep. Yeah, man. So I'm gonna end it off like that, bro. That's some powerful stuff right there.
Yeah, man.
I was still talking to you about your dating life and all this BS, but I don't really
do that for the next episode. Next week.
So hey, thank you, John, for coming on, and thank you for all our listeners. And John, man, I think when you try a case with someone, it develops like a bond, especially a tough case. And you try a case with someone, it develops this bond. You guys learn how to operate each other. And I remember I read a lot of books on like military books and Navy SEALs. You guys know I like that philosophy.
Yeah.
It's like, it's true, man. You know, you got to, those guys, those elite fighters, they know their teammates. They know like, hey, this is how he moves. I can spot John a mile away, man. I know how he moves. So it's been an honor. It's been great trying cases with you. And I look forward, man. I think we're going to get this big win on this next case. And we got a lot of people to take care of in the future, and we're gonna do some good work together, brother.
Yeah, I think so. I appreciate you giving me the opportunity to try the case with you, and you're my brother, and I look forward to this trial we have coming up October 24th.
Yeah.
I think we're gonna do an amazing job and get our clients some justice.
Yeah, man, I think we are too, man. And I want to get hope for the Dodgers World Series too. Nice, man. But,
yeah, there
thanks,
you go.
John. Thanks for coming on, brother.
Thank you,
appreciate it, man.
Yeah.
Thank you, man.
Yeah, thank
appreciate
you.
it. Thank you for listening to this episode of Beyond the Bar. If you enjoyed this episode, please share and subscribe to the podcast. For more podcast episodes, please visit sepulvedalawgroup.com/podcast.